I oppose the request by the state is because I also researched and checked the legal position regarding to the statements that were disclosed to me. That was disclosed to me, which were the affidavits of the investigating officer. And the state has not indicated any objection. And when an order was, or when the witness was asked to read the statement, then he raised that objection.
Okay, so
But
which statement is this? I don't know what you're talking about.
The statement is the statement of the investigating officer of Brigadier Kininda.
It's a statement by Brigadier.
Yes, not of the witness.
What does it concern?
My Lord, it relates to the participants in the commission of the alleged offense, and it won't actually be open to the court to give an informed judgment if there are certain aspects that are claimed to be privileged or to be redacted without reasons. In this case, an affidavit has been made. It's almost the same affidavit as the one that Brigadier Kininda has read on record. It's an additional paragraphs.
Does it concern a trial within a trial?
It is, my Lord. It is, but particularly on the subject of 219.
Mr. Baloi?
As a court, please, my Lord, we maintain that this information is irrelevant as far as the trial within a trial is concerned. But over and above that, my Lord, we feel that it will be unfair to any individual or individuals to hear their names mentioned in court without them having been warned and without them having been afforded the opportunity to come and make their own representations. We submit, my Lord, that in a constitutional dispensation as ours, this cannot be allowed, my Lord. There are no advantage, or there's no advantage to be gained by placing this information on record. As far as my land friend is
concerned. When you say by placing it on record, I hear you. Yes. You know what? I've been lax in applying the law because I'm told, you're interfering. I've allowed so much leeway, people bringing evidence which has got nothing to do with the concept of a trial within the trial. Are you with me? Because this is a circumscribed interlocutory application. It's circumscribed, trial within a trial. And once you have used that evidence within a trial within a trial, you may possibly not use it in the general trial. Mr. Am I talking sense?
Yes, my Lord.
But I've been lax. Mr. Gumezulu can tell you, he has gone to the Antarctic and it comes back. For instance, now we're starting again in the Antarctic. You remember the statement you read?
Yes.
Which now he says it reminds him of something which you say accused number one was boasting about.
Yes.
Now, I don't know what he wants to prove about this, but I don't want to stop you. You can do what you think you must do. But when I come to adjudicate the matter, I will be guided by the dictates of a trial within a trial. But I can't stop you from doing that because I'm told I'm interfering. So go ahead, do what you think you want to prove. Sir. You don't want to encumber or abridge your testimonial duties as prescribed by your instructions. Okay.
Nizokhumbula ngaphambi kokuthi siphume ummeli uNgomezulu wayekade ethe uBrigadier Kininda afunde istatement esithize. Manje uma sibuya umshushisi uyacela uthi kunengxenye zazo le statement acela ukuthi zingafundwa akathi statement sonke singafundwa uthi ingxenye ze statement zingafundwa ngoba kunamagama wabantu ayikuthi ayashiwo kuleso statement labo bantu ubona ukuthi izobakhinyebeza ngenxa yokuthi labo bantu abakatshelwa ukuthi kunamagama wabo kulezi statement futhi abatshelwanga nokuthi nanamuhla kuzofundwa amagama wabo aphumele sobala la ukuthi ubona ukuthi umshushisi ngeke iphathe labo bantu kahle futhi nakuleli cala akusukuthi kunento ethize izoguquka ngemva kokuthi lawo magama ashiwo kodwa ukuvikela labo bantu ngenxa yokuthi abaziswanga manje uyacela ukuthi yena lawo leyo ngxenye yaleso statement ingafundwa ummeli wenu uthi yena ayifundwe yena akabone kunenkinga nanoma labo bantu bangaziswanga inkantolo ithi ilibele yelule isandla ifuna ukuthi lelicala liqhubeke kodwa kunenye indawo la ukuthi ilibele yenza izinto ngoba abameli bathi iyeka okunye okomthetho kodwa manje inkantolo ibona ukuthi ingathi sekuzofikela la izogcina seyithi umthetho uthi akulandelelwe umthetho ngoba sikulesi sigaba ese-trial within a trial sokuthi kunobufakazi obuthize obukhulunywa ngabo lobo bufakazi khona kulesi sigaba bungasetshenziswa noma umuntu angakhetha ukuthi angabusebenzisi icala mase selizoqhubeka sesikuleyana ebizwa i-trial.
Okay, so you're at liberty, Mr. Ngomezulu, to do what your duty intends you to do.
May I please ask the court, my lord, to the court, the witness to read the affidavit.
Read?
To read the affidavit.
Are you not going to prove the statement?
No.
Oh, you must read it.
Yes.
Yes, Mr. Baloi, what is the law? What does the law prescribe?
Well, my lord, the law is very clear that no statement can be used unless it has been proven. And that is the steps that my learned colleague should follow.
Yes, Mr. Ngumezulu, you can start. You want him to read it, but
Just to read the statement,
by not laying down the legal
or the
protocol
basis. My lord,
because then it is not a sworn statement. You understand it?
It is a sworn statement.
No, it is sworn until. It is sworn.
May I
But
read
until, wait. If you want it to get onto the record,
Yes.
then you've got a legal duty to prove that the law was complied with when the statement was made
Yes.
to be a sworn statement.
Correct.
Okay, fine. You can proceed.
Thank you. Sir, Brigadier Kininda, is it correct that you are the deponent of the statement A227?
That is correct, my lord.
Kuyiqiniso ukuthi wena obhalele lesi statement uthi yebo iqiniso.
Is it correct that you actually read you're the one who wrote the statement by yourself?
That is correct, my lord.
We osibhale ngokwakho uthi yebo yimi.
So did you read back the statement to the satisfaction of the contents that are contained therein?
No, I made a statement, my lord. It's my statement. I
Yes.
made it.
Usifundile le statement ngemva kokuthi usibhale uthi mina yimina ongisibhalile bekungena sidingo sokuthi ngisifunde.
Did you sign the statement
Correct, my lord.
Usayinile uthi yebo ngisayinile.
in the presence of the Commissioner of Oath?
That is correct, my lord.
Usayine ngaphambi komuntu obekade esichithiza istembu uthi yebo.
Is the statement binding in your conscience?
That is correct, my lord.
Leso statement siphethene sihlangabezane nonembeza wakho uthi yebo.
So do you correct the truthfulness of that statement?
Yes, I do, my lord.
Leso statement siyiqiniso uthi yebo.
The date in which you signed the statement?
It was 20 November 2020, my lord.
Usayine nini uthi nge-20 zika November 2020.
Thank you, my lord. I beg leave for the witness to read the statement on record.
Okay, sir.
Cela ukuthi asifunde uyafunda ke uBrigadier Kininda.
My Lord, it reads as follows. I, the undersigned, Bongani Nicholas Kininda, state under oath as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same Act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit of the National Commissioner with the rank of a colonel. I've mentioned the service number, my Lord, and the telephone number, which I would like to skip. Paragraph 2, I am the lead investigating officer of Phosphorus Case 636 of 10/2014, which is a case of murder where one Senzo MEYIWA was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. This deceased was shot at the house belonging to then his girlfriend, namely Kelly Khumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the suspects was carrying a firearm purporting to be a revolver. The accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as tall, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo MEYIWA, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased, Senzo MEYIWA, on close range on his chest and exited at the back of his body. The second suspect, who is now accused 2, focused on the rest of the witnesses in the process. 1 cellular phone belonging to Miss Kelly Khumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others a hoodie, were standing hidden away but only a few meters from the crime scene prior to the incident appearing to be typing on their cell phones. It is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikit was compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 2030 and 2100 hours. The deceased was declared dead on arrival at the hospital at 21:15. Investigation further revealed, paragraph 3, my Lord. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost, covering the area of Phosphorus Hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under oath indicates that the planning of the offense and gathering after the incident took place at Phosphorus Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo MEYIWA. The suspects are as follows. 3.1 Musika Ukhulelwa's Tembas Biya. He was first linked to this offense by means of witnesses' statements under oath. The accused boasted to individuals closely associated with him in KZN Homeland as to his involvement together with Mafiga, herein under suspect 2, Carlos herein under suspect 3, Mapisa herein under suspect 4, and Nkani herein under suspect 5, into the killing of the deceased. A dispute ensued between these individuals. and the closely associated individuals disclosed to the SAPS the admissions this accused made to them. The accused was further linked with circumstantial evidence wherein he, minutes after the incident, made disclosures and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo, even before the death was reported in the media. He is further linked by means of a formal confession he made to the commissioned independent officer on the 30th of May 2020. In this confession, he clearly implicates Ms. Kelly Khumalo as the person who gave them the instruction to kill Senzo MEYIWA. The suspect further made a formal pointing out the scene collection prior to the incident, the gathering of the outside of the house during the assassination, and the dropping off of the accused at the cell phone tower referred to herein above. The pointing out by this accused identified the exact scene, place, house where the deceased was shot. The accused identified the place, position he held when this offense was committed. In place in terms of his pointing out is accurate and meshes out the crime scene. The pointing out was made to another commissioned officer on the 6th of June 2020. Here, my lord, is the mistake. It should be the 5th of June, because that's when the pointing out was made.
Okay.
The accused was further linked by a witch doctor he attended prior and after the killing of Senzo MEYIWA. The said witch doctor's premises were identified by this accused. After the said doctor was found, the said doctor was taken to our offices for interview. It was during this movement in the office that the witch doctor came across this accused. The said doctor recognized accused in my presence and said he recalled also that he once came with Mapisa from Phosphorus to him, but this accused denied the involvement of Mapisa and insisted to the witch doctor that he came only with the Uteleze brothers. At this stage of the investigation, the presence of Mapisa is one of the suspect. The name of Mapisa is one of the suspect that was known to me, but it later became evident that this accused was hiding the presence of Mapisa to the police. The accused was initially confronted with the identikit of the suspect with the dreadlock as the person resembles his looks. The accused was formally warned according to his constitutional rights prior to the questioning. It was under these circumstances that he decided to make a confession, but clearly stating that he was not the shooter and that he was standing outside. He further indicated that Senzo was shot on the chest. He was confronted with this knowledge and how he know the exact spot of the wound if he did not do it or was not in the house. He then implicated one Marco Butelezi as the shooter and the person who told him. He further said he was willing to make a confession and pointing out at the crime scene freely and voluntarily without any undue influence. 3.2 Bongani Sandisontanzi. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identity kit complied to the description to the witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and the compiled identikits. During the questioning and subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. The accused was warned according to his constitutional rights and then interviewed about the suspicious conviction that creates the belief that he was involved in the death of Senzo MEYIWA. The accused immediately said that he remembers that the incident took place on the 26th of October 2014, and that on that specific day he was at work in Rustenburg. I requested the accused to identify the said place of work, which he voluntarily identified. Upon proceeding and arriving at the premises of his previous employer, it was discovered through evidence obtained under oath that this accused lied about his whereabouts. In fact, he was on absent without leave from the 25th of October 2014 to the 3rd of November 2014. Hereafter, the suspect indicated his eagerness to confess as to his involvement in the matter. The suspect made a commission to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Magistrate Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as tall, slender built, which came into the house. He also implicates Ms. Kelly Khumalo as the person who gave the order to kill Senzo MEYIWA. 3.3. Mtobisi Prince Mngube, nicknamed Carlos. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was a sentenced prisoner serving 35 years in prison for the murder committed in 2015. Ballistic tests reveal that the same firearm used in the murder for which the accused was serving his sentence was used in the murder of Senzo MEYIWA. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloads of this cell phone were done. Photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver entering the house. Photos downloaded taken of the accused by him, selfies, during the day of the 26th October 2014 matched the description of the suspect who had the firearm with dreadlocks, big eyes and with gold teeth. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Evidence confirms that he is Zulu speaking. In fact, all accused in this matter are Zulu speaking and knows each other. Photos were equally found of the murder weapon used in the murder of Senzo MEYIWA. A photo containing the exact bag of money similar to the one found in Ms. Kelly Khumalo was found. There is also another selfie that was taken by the cell phone of this accused, which shows him having a gold teeth. The gold tooth was one of the things that was noted by the witnesses. It is imperative to mention that this accused currently does not have the gold tooth as well as the dreadlocks, but evidence shows that he had both in 2014, October 26. Mtuguziseni Zipozonke Mapisa, also known as Mapisa. This suspect, this is 3.4 Malot, this suspect is linked to this offense by means of certified sworn statements and referred to herein above. He is further linked by means of a confession he made to a private person, a close friend, about his involvement in this matter. The confession came about in that this suspect requested this private person to establish the reason why suspect Mafika was arrested. The information disclosed was that the suspect Mafika was not only arrested for ammunition but also for the MEYIWA murder. Upon the private person returned disclosing this information to suspect Mapisa, did Mapisa instruct the private person to return to and inform suspect Mafiga not to disclose his brackets Mapisa involvement as he Mafiga will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5 Sifokuhle Nkani Ntuli, also known as Nkani. The suspect is linked by means of a sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo with registration CT49YZGP before, during and after the murder of the deceased. Evidence also reveals that he drove the car with the suspect to the crime scene and back to Phosphorus Hostel after the incident. The accused is linked by cell phone analyst by means of a cell phone links to Miss Kelly Khumalo. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafiga, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the vehicle prior to and after the committal of the offense in the company of the referred suspect above. The above suspects are also known as hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35/108 of 1996 by me and questioned for this incident. Some of the suspects made confession to independent commissioned officers as well as magistrate as indicated above. Others made confession as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence on the cell phone analyst links him to Kelly Khumalo. 3.6 Nonhlanhla Kelly Khumalo. 4 cell phone numbers that she did not disclose to the police when this incident took place. These numbers were discovered by the XDS system used by the cell phone analyst and subsequently linked to her activities. The numbers are as follows: 079-494-4358, 073-451-5017, 073-886730, 061-456-2108. Investigation further revealed that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis, her cell phone memory album has the same photo of a see-through bag containing cash, notes, and in the exact position or location or spot of that of accused number 3. There is no reasonable explanation as to why Kelly Khumalo will be in contact telephonically with a headman or killers of a boyfriend and share the same picture of a bag full of money. Communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it. It is apparently clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all these facts, an inference can be drawn that she meant killing him. Cell phone record shows that after the incident took place, she phoned a number of people from 082-703-4358 number, but no call was made to emergency services. She also subsequently went to the witch doctor for cleansing, as was also done by the other accused in this matter. The statement of Ms. Mkhize, who is an expert in this matter, clearly indicates that this is not normally or how it should be done, especially if one is innocent. Evidence by means of a sworn, corroborating and independent witness statement established a casual link between the offenders and the offenses of murder, robbery and aggravating circumstances, possession of unlicensed firearm and unlawful possession of ammunition, and conspiracy to commit murder. Ms. Kelly Khumalo seems to be the trigger point of this murder. Then paragraph 5, my lord, which is the last one, is basically the oath, and I signed. It was commissioned on 2020 November the 20th.
Yeah, just one query before Mr. Gomezulu starts. You read, you say there's a casual relationship, it's causal.
Causal relation. Thank you, my lord.
Because I understand a bit of English.
Thank you, my lord. Causal relation.
Right. Yes, sir.
Sorry, my lord, there's one last page at the back which I didn't go to. It's basically a J50 application warrant which was not signed for Ms. Kelly Khumalo. So, because it forms
it is in the...
It's part of the statement.
Yeah, it's part of it. Okay, fine, I hear you. But I say it's in the link of exhibits.
Yes, my lord. I suppose. I wouldn't know.
Yeah, okay, fine. Yes, yes. Oh yeah, by the way, you've got to interpret.
As the court pleases. Lesi statement siyafana cishe naleziyana esifundwe ngomsombuluko. Lesi sihluka nje ngokuthi sifaka igama ukuthi umangalelo oqala uye washo ke ukuthi ubani umuntu obekade ethe bayobulala umnumzana uSenzo MEYIWA. La yikuthi umangalelo oqala uchaze ukuthi bekade bethunyelwe uKelly Khumalo eyikuthi uye obekade ebatshele ukuthi babulale uSenzo MEYIWA. Nomangalelo wesibini naye uma eqhubeka ngemva kokuthi sekaphunyuluka kulaye ukuthi uye wachaza naye ukuthi uKelly Khumalo uyena obekade ebatshele ukuthi bayobulala umnumzana uSenzo MEYIWA. Bese ke umangalelo wesithathu naye uyabandakaneka kulo lelicala leli la ukuthi yena umangalelo wesithathu uCarlos kuthiwa ubekade naye ekhulume nabanye abantu abathize labo bantu nabo bathathe istatement bafunga phambi kwamaphoyisa ukuthi lezi zinto abazishoyo kuyiqiniso futhi kuthiwa uCarlos kahle kahle nani nonke nikhuluma isiZulu futhi buye kwashiwo ukuthi efonini kaCarlos yekwatholakala isithombe ebesikade sibonisa isikhwama esithize ebesibonakala sinemali ngaphakathi. Leso sithombe satholakala efonini yakhe uCarlos eyikuthi ithe isikhathi masiqhubeka kuye kwatholakala nokuthi futhi efonini yakhe uKelly Khumalo wakade kunaso leso sithombe esifana ncamashi nalesiyana esikuyifoni yaka Carlos. Futhi ke umangalelwa wesine ke yena utholakele ngokuthi naye bekade ekhulume nomuntu othize. Lo muntu wagcina sekambuza ukuthi manje akungichazisele kufike kanjani ukuthi umafika agcine seyikuthi uyaboshwa. Umaphisa wamthumela ke wathi awuke uye uyohlola ubuze imibuzo ethize. Ithe makabuya lo muntu lo ongakhulunywanga igama lakhe wathi yena ukhulumile nomafika umafika umtshele ukuthi uboshwe leli yaqala futhi umaphisa wathumela lo yamuntu wathi hamba uyomtshela umaphisa ukuthi angakhulumi ukuthi kwenzakeleni kuthunyelwe ubani angalinge nje akhulume ngoba uzogcina naye sekabulawa. Umangalelwa wesihlanu yena ubandakanyiswa ngokuthi uyena obekade eshayela imoto bekade kuyinhlobo ye-VW iPolo number plate yakhona CT79YZGP wabonwa ayishayela ngaphambi kokuthi kwenzakale lesi sigameko nangemva kokuthi isigameko senzeke uye wabonwa ekade eshayela leyo moto futhi naye uye wacebisa ukuthi umafika angakhulumi ukuthi kwenzakeleni ngalesikhathi kuze bekubulawa umnumzana uSenzo MEYIWA. Kuthiwa ke abamangalelwa bonke bona baziwa ngeinkabi ebezikade zinokubulala abantu uma kunezimpi zamathekisi. Kwacebiswa futhi umafika ukuthi angalinge akhulume ecetshiswana futhi umangalelwa wesihlanu ukuthi angalinge akhulume ukuthi kwenzakeleni ngoba naye angagcina seyikuthi uyabulawa. Bufakazi bubonakalisile futhi ukuthi uKelly Khumalo naye uyabandakanyiseka kuleli cala. Manje ke uKelly Khumalo yena kunamanombolo athize ayikuthi uye waxhumana nawo, kodwa kuthiwa umuntu omsulwa akwamelanga ukuthi ayenze kanjalo uma sekunecala sekunengozi evelile. Nawa amanombolo kuthiwa mane, nombolo yokuqala 079 494 4358, yesibini 073 451 5017, yesithathu 073 388 6730, eyokugcina 061 4562104. Lawo manombolo akushiwo ngokuthi awakabani, kodwa uyabonakala ukuthi uKelly Khumalo naye ubeke washo ukuthi ubekade ekhulumisene nabamangalelwa, ngoba kunala ukuthi ithombe nazo ziye zatholakala la umangalelwa wesithathu atholakele khona. Kukhulunywa ngalesa sithombe salesiya sikhwama lesibili kade sinemali, futhi uma kuqhutshekwa kuhlolwa i-cellphone yakaKelly Khumalo kuye kwabonakaliswa ukuthi inamba eyikuthi ubekade eyisebenzisa beku 0827044358, la ukuthi naye-ke uye wagcina seyikuthi uya enyangeni eyozigeza, njengoba nabo abamangalelwa bebakade bayile enyangeni bayozigeza ngaphambi nangemva kokuthi kubulawe umnumzana uSenzo MEYIWA. Bufakazi buyabonakalisa kwi-statement ukuthi umuntu uye waya emaphoyiseni yena wafunga ukuthi bekade kunecala lokubulala futhi necala lokubamba inkunzi kuhlonyiwe, nokuthi bekade kunecala lekubanjwa isibhamu ngendlela engekho emthethweni, nezinhlamvu bezikade zingekho emthethweni ukuthi kuyobulawa umuntu. uKelly Khumalo kubonakala ingathi uyena umuntu oyikuthi uye wathumela lezi inkabi ukuthi ziye ziyokwenza leli cala. Brigadier ufungile naye ukuthi zonke lezi zinto ezibhalwe kulesi statement iqiniso, futhi uthi nasi esinye kodwa lesi asizange sisayinwe, bekade kuyincwadi ebekade ecela ukugunyazwa kokuboshwa kukaKelly Khumalo as the parties. Thank you.
Okay, thanks. Mr. Gomezulu?
My Lord, thank as the court, please. May I request the statement to be handed in, my Lord?
Yes. What will be the exhibit?
Exhibit ZZ.
ZZ.
We just want to maybe one Leonard felt that it refers to the confessions and the pointing outs, which are the subject matter of this trial within a trial, and which might be to the detriment of the defense.
What do you say about that remark by Mr. Baloyi?
I have no response.
Hello?
I have no response, my Lord, to this.
What do you mean you have no response?
If he says to the detriment, the time has come to argue this matter.
No, he says there's a potential prejudice against the disclosure of this statement vis-a-vis your clients, accused 1 and 2. Is that what you're saying, Mr. Baloyi? Right. So,
Yes.
I mean, I did say to you, you have veered off from the principles of a trial within a trial.
Yes.
So I don't want to circumscribe your cross-examination, whatever, but you have been forewarned. And now, even your learned colleague here is saying the disclosure of this statement may presage the contents of the alleged confessions. Are you with me?
I'm with you, my Lord.
Okay, so you are free to cross-examine.
Thank you.
Umele ucela ukuthi lesi statement sinikezelwe enkantolo njengobufakazi umshuthisi uyaphakama uthi ucela umele ukuthi lesi statement masikezelwa kwenkantolo azi ukuthi singahle sifake abamangalelwa wokuqala nowesibini esimene esiqayi uma lesi statement sifakwa njengobufakazi kwenkantolo.
Okay.
Thank you. Court pleases, my Lord. The attached document at the back of the statement was not part of the document attached when you brought the application for a warrant of arrest.
I don't. Can I ask Defense my lord to clarify the question? I don't follow.
I'm saying, when you brought an application under Section 43, the 23rd, if I'm not mistaken, October, the warrant of arrest, the J50, bearing the name Kelly Khumalo, was not part of the documents that we...
No, it wasn't, my lord. That statement was made in November, and the application for J50 for Kelly Khumalo was made at that stage, my lord, November 2020.
Le ncwadi ebe ucela ukugunyaza ukuboshwa kuka Kelly Khumalo beyikade ikhona na ngalesa sikhathi wenza le statement cha le statement isiyenzwe ngo-2020 le ncwadi yona iyenzwe ngemva kwalokho.
Thank you. May I proceed to establish from your brigadier in terms of the discretion. Did you take any discretion to stay or not to apply for a warrant of arrest against Kelly Khumalo?
No, I did not, my lord. As I indicated, this case, this matter was a procedural-driven investigation. Now, prior to the application of the warrants that was made on the 23rd of October 2020, I've indicated in my evidence in chief that I made presentations, or not presentation, a memorandum to the DPP, where the not-helping one, where I indicated all the evidence that we have on all implicated people, including Ms. Kelly Khumalo. She is there. The decision was taken at that time that these are the people that must be indicted, and that is accused 1 to 5. I cannot disclose further details in terms of our discussion with the NPA, my lord, but there were certain things that needed to be looked into insofar as Ms. Kelly Khumalo. Then the following month, when we've covered some more grounds than then, that's when now I made a presentation again to say, this is where we are, and we're making this proposal.
When Brigadier uye wathatha isinqumo noma wacabanga ngokuthi mhlawumbe le ncwadi le ebunyaza ukuthi uKelly Khumalo aboshwe ingahle iqhubekiswe na uthi cha angizange mina nyenze kanjalo mina bengikade ngiphenya lecala kulibele kuphenywa yonke into futhi ithema kuqedwa kulayi ukuthi mina ngiyengaya kubaphathi babashushisi ngiyofaka isicelo sokuthi nabo abamangalelwa ukuthi mina nginabo nginokufakazi ngakubo ukubandakanyisa naye uKelly Khumalo la ukuthi ke bona abashushisi baye bathi naba abantu ukuthi bakwamele bashushiswe okwamanje njengoba kungakaqedwa uphenyo yena ubrigadier akazange athi akushushiswe labantu uKelly Khumalo yena ayena.
In the light of the fact that if the evidence that accused number 2 made 2 confessions, one before Colonel Rapado and the other one before Magistrate Mrs. Cronier, was it also your discretion that it was not necessary for accused number 1 to be taken before another magistrate after he has made a confession or the alleged confession before Colonel Mboto?
No, my lord. I think I've explained this part. So the magistrate part for accused number 2 came as a result of a 105A communication between ourselves and the state prosecutors. That's how it kicked in. I was satisfied with the confession that was made because it missed the merit. It's a commission officer, he's a justice of the peace, there was a confession. Subsequent to us engaging with the attorney for accused number 2, And in discussion with the plea bargaining with the state, it flowed from there, my lord. Then there was this confession for accused number 2, which was not the case with accused number 1.
Awuzange ke ucabanga ukuthi ummangalelwa lokuqala naye bebamele ayiswe ayogunyuluka phambi komantshi njengommangalelwa wesibili. Uthi ngemva kokuthi bese sesikhulumisene nabashushisi kulayi ukuthi ummangalelwa wesibili bese sesiyesathatha kwaxoxwa futhi njengoba bekayenze nalesi sicelo sokuthi yena kube ufakazi kugcine seyikuthi unikwa isigwebo esingaphansi. Ngemva kwalokho kulayi ukuthi siyesathi sanelisekile ukuthi ummangalelwa uqedile ugunyulukile bese kwathathwa ke nalesi sinqumo sabona ukuthi naso ummangalelwa wokuqala ubekade egunyuluke kumuntu onayo imvume yokuthi angalalela istatement esifana nazo lezo lo muntu ngikhuluma ngaye uKenneth.
Thank you, Brigadier. I'm well aware that such an engagement was done between the representative of accused number 2, as you say. But I just want to get into the point of accused number 2 being represented. The evidence, according to the state, is that the said person on the 24th of June 2020 was present when accused number 2 make a confession or the alleged confession. Secondly, the evidence that the state has is that the same attorney also participated in the plea bargaining agreement, and to the extent that such a decision or such a plea bargaining agreement was not concluded or finalized.
So
The question.
must I comment?
Yes,
What is the
I
question?
just wanted to ask a question. Throughout the involvement of Mr. Mchiako, the alleged Mr. Mchiako, firstly, before I proceed with the question, was the agreement concluded, the plea bargaining agreement, in terms of section 105, capital letter A?
My lord, yes, it was. So there was. It was not only Mr. Mchiako when the 105 capital A was involved. There was also another advocate who came on board. I mean, those are the issues that because they form part of the discussions, and there was proposals and affirmations of standing with the confessions that were made by accused to the magistrate and Lieutenant Colonel Rapad, and the proposal of him testifying against his co-accused for a specific sentence, which we were of the view as the state that we are not happy with that sentence. The deadlock, it was concluded, because there's a formal communication, it was concluded. The difference was on the proposed sentence from the defense side in terms of what accused 2 is prepared to do in relation. There was a specific sentence that is sent to us and said, I'm prepared to serve this sentence and in this manner, and then in return, I will testify against my co-accused, etc., etc. So it was formal and finalized.
Yebo bekuye kwaqedwa inkulumo phakathi kwabashushisi amaphoyisa nommeli ummeli umjiyapha kusiyana yedwa khona omunye ummeli into bengikade ngingafuni ukuyiveza kodwa ngoba seyabuzwa nakho ke kwamele ngiyiveze ukuthi siye sahlulana nje uma sesekufika kwisigwebo lesi ummangalelo wesibini wayekade ethe yena uzimisela ukuthi angasiya ejele noma ahlale endaweni ethize noma ahlale kanjani leso sigwebo leso kula siye sahlukana khona futhi ummangalelo wesibini yena bekathe uzimisela ukuthi angayenza leso sigwebo bese uyabuya abe ufakazi wombuso afakaze kulento ukuthi abamangalelwa abane laba abanye bayenzile kulo lecala.
My Lord, it's also prudent to mention that in this communication, I remember one document, he clearly admits that he stands with the two confessions that he made. And these discussions, my Lord, were taking place after the matter was enrolled. It was not discussion that took place before the first appearance on the 27th of October 2020. While the matter was going on after the first appearance, second appearance, those discussions were taking place so that one can decide where he must be placed. That is why at some stage the court would have seen that in the occurrence book he spent also a lot of time in police stations, because there was these discussions, and it was put by I think on the first appearance the request was made by him in court. Mr. Mchololo was there for accused to be kept at the police station. It was because there were these part of discussions that were taking place confidentially.
Futhi le inkulumo lezi ziyenzakele leli cala liselingenile enkantolo, akusukuthi leqalwa ukuthi abamangalelwa bavele enkantolo bese sekulibele bevile enkantolo. Ingakho ummangalelo wesibini yena uNtanzi wayelibele ebekwe esitokisini samaphoyisa isikhathi esiningi, futhi uthi nommeli uMshololo wayekade ekhona ngalesikhathi uNtanzi eyenza leso sicelo. Akusukuthi bavele bayicabangela ukuthi uNtanzi yena angafakwa nabanye esitokisini kungenxa yokuthi bekusakhulunyiswana.
Thank you.
Once again, we just want to sound a word of caution to my learned friend that in terms of section 105A, if there's a proposal, a 105A proposal, if it falls flat, reference may not be made to it in any other manner. But if he elects to elicit that information, he does so at his own peril.
Umshutshisi ucela ukucebisa ummeli uMngomezulu ukuthi le mvumelwano leyana noma le yankulumo akusiyinto eyikuthi kungahle kudingidwe ngayo, kodwa uma ingabe uyafuna ukuqhubeka lapho angahle ahlabele umgaqo.
Thank you, my Lord. I'm not intending to get into the gist of.
Oh, you're not disputing it.
Now,
It's one matter to not intending to get into the gist of it.
not that I'm not disputing
Okay,
it. Not that I'm not disputing it. My, in fact, I'm concerned about the representative, the legal representative, or the mandate that Mr. Mjiako alleged to have been given by accused number 2 to represent him. That, according to you, Brigadier, is there any power of attorney that was furnished by Mr. Mjiako?
My Lord, I don't think I have authority to ask him to show me the power of attorney. When I met him on the 23rd, the first time, 23rd of June, after I was informed that there's a gentleman who is saying he's an attorney for accused number 2. I don't know how they communicated. I went there, my instruction, and I've said this in evidence in chief, my Lord, that I said they must allow him, despite the COVID regulation, because it was a legal visit. I arrived, he identified himself, gave me a proof from the LPC, which I verified, and later we get a confirmation from people. Other than that, my Lord, I don't think I could have taken it any further. I don't think I have authority to say, give me the power of attorney. All I wanted to know was to confirm when I arrived, if he was legally, if he was indeed an attorney, that was confirmed. And subsequent to the proceeding that followed, I was convinced he was an attorney, my Lord, because like I said, he appeared numerous times on this matter from the time of its inception and subsequently in Pukeng as well, my Lord. And then thirdly, the discussions in terms of section 105 with the state and with the advocate that he appointed at that time, my Lord.
You don't want to disclose the advocate?
I know the surname was Buchelezi, my Lord. I remember the surname was advocate Buchelezi.
Okay.
Uthi ke wena ke brigadier ubona ukuthi ummeli lo uMjiako wayekade enalo ilungelo na lokumela ummangalelo wesibini. Uthi mina anginalo lelo gunya lokuthi ngimbuza ukuthi unalo ilungelo. Ngitshelwe ukuthi kuthwa uthi uzomela uNtanzi ngathi abamvumele ngenxa yokuthi bekunale labhubhane lo COVID-19 ngathi abamvumele nami the mangifika wanginika ke incwadi ebonisayo ukuthi buya khona kubaphathi bama lawyer waphinda futhi ngambona futhi nasenkantolo kulo leli cala leli futhi nasephukeni ngambona nangokho bekungasuyena yedwa lo munye owesibini angilazi igama lakhe ngazi nje isibongo sakhe kwakade kungowakabuthelezi.
Lastly, my lord, also I've indicated that on the 23rd, as I was approaching an Arabic police station, it is accused number 2 who first stood up and said, "This is my attorney," to me. Secondly, on the first appearance, because I was there, it was asked, accused 2 confirmed that he, Mr. Mjiako, is his legal representative. It's on record, it was televised, my lord, it's there.
Futhi ke enye into yesibili esemqoka uthi ithe yena mayifika lapha esiphoyiseni kulayo ukuthi umangalelo wesibini uyena watshela ubrigadier ukuthi nawu ummeli wami futhi nayiqala uma lingena enkantolo belikade liboniswa nakumabona kude umangalelo wesibini washo nakhona ukuthi ummeli wakhe uyena umjiyako.
Sir Brigadier, with due respect, if the court were to grant us leave to produce the clip, accused number 2, you were present, and he instructed me that when he was addressing the magistrate to the effect that I don't want this attorney, Mr. Mjiako responded, the presiding officer said, "I can't listen to you if you are represented." Did you observe that, sir?
Not only, but that's not true, my lord. I was there, that's not true. Like I said, Mr. Mcholo was there, the state advocate was there, a number of people were there, journalists were there. There is no way where accused 2 said in that the first appearance that he does not want Mr. Mjiako. That's absolutely not true. That's why even the request of where he must be incarcerated came through the attorney, Mr. Mjiako. And accused 2 moved with us for that incarceration during that time. So that is not correct, my lord.
Manje ke uthi ummeli umngomezulu brigadier akusiqiniso lento ewuyishoyo ngoba ngalesa sikhathi ummangalelwa evela enkantolo uye waphakamisa isandla wathi yena akafuni umjiyakho kodwa umantshi wathi ngeke ngikulalele wena Ntanzi ngoba unommeli nangokho ummangalelwa besisekathe yena akamfuni umjiyakho futhi naye ummeli umjiyakho uyena owaqhubeka efaka nalesi sicelo sokuthi ummangalelwa athathwe ahlaliswe endaweni yakhe eyedwa futhi uthi bebakhona umshushisi wayekhona uyaphinda futhi uthi nommeli umshololo wayekade ekhona neintatheli zazikhona ngalelo langa ayikho lento yokuthi umantshi wathi ngeke alalele uNtanzi ngoba enommeli uyakuchitha lokho ubrigadier.
Mr. Ngomezulu, I hear you saying you're thinking while there, no. Maybe it would be necessary for the clip to be played. Did I hear you correctly, sir?
That's correct, my lord.
No, but does the law allow it? Remember, those proceedings were nullified. Now the question is, are you saying the proceedings in the regional court are not part and parcel of the subsequent proceedings which inured before my colleague?
My lord,
just listen to me, because
yes,
you can think it's something simple. So if the proceedings start from the regional court,
yes,
and then they are postponed in terms of section 72C to the High Court, those are the same proceedings. And when subsequently there's a plea and the proceedings before what's my colleague's name by the way? Right. Sorry, yeah, thanks. Mr. Judge Maumela, they proceed. And subsequently, through an order of this court, before I was appointed to take over the matter, they are nullified. Are you with me?
I'm with you, my lord.
Can you have the right to think loud, like you are thinking, to say that tape of the first appearance in the regional court must be played? I don't think so. Me.
May I
What
be,
do you think?
may I be afforded an opportunity to
To check the law.
check the law, my lord? Then I'll make proper submissions. I'll be guessing.
Yeah, me, I'm certain. The proceedings didn't be. That's why, for instance, Section 337, you can quote the record of the regional court in the High Court. For instance, the bail application.
Yes.
When you argue bail application in the High Court, in the District Court or the Regional Court, that evidence of the bail application is admissible in the High Court, meaning that, in my view, those are single proceedings which commenced when the accused were indicted and appeared in the Regional Court. What do you say, Mr. Baloyi? Let me hear your wisdom.
Well, our view is that the proceedings that were set aside are the proceedings that served before Judge Maumela, and the proceedings in the lower court, in the district form, stand separately from those proceedings in the High Court. In fact, the charge sheet was not even handed up at that stage. So it was only the indictment and the evidence that was laid before Judge Maumela that were set aside. The proceedings in the lower court did not form part of the proceedings in the High Court. The charge sheet was not handed up.
Okay, who wants to address this matter? Let's hear Ms. Mshonolo. Any view?
My lord, I confirm that the proceedings for the magistrate court did not form part of the proceedings which were before Judge Maumela.
Okay.
Therefore, we can still make references to that record.
Okay, Mr. Khumalo.
Thank you, my lord. You can still make reference to that record.
Mr. Misi, you were the big prosecutor in the NPA, formally,
I share the same sentiment.
with them.
Yes. Thank you.
Okay, me, I'm making a ruling that that is not so. They're the same proceedings. Go and check your law. The same accused were arraigned before a magistrate. In terms of Section 72C, those proceedings before the magistrate under the same docket, under the same indictment which is subsequently drawn by the NPA, the Director of Public Prosecutions. They are superimposed and promoted, and continued before my colleague. That's why, for instance, anything that happened in the regional court, you can refer to it like Mr. Gomezulu wants to say. For instance, if there was a dispute about the bail application, he said this, he didn't say that. The record of the proceedings in the regional court are applicable as evidence also in the High Court. Go and check Section 337. Is that not so? Is it 337?
That's correct.
Just quote it.
Yeah, well, as you mentioned, my lord, our view is that
Okay.
the proceedings in the High Court starts with the service of indictment in terms of Section 144. So it's a completely new process that starts in the High Court. The Director of Public Prosecutions draws up an indictment as well as a written notice for the accused to appear in court. It's served on the accused in the lower court, and he then appears in the High Court on a new indictment, and the proceedings then commence in the High Court.
Okay, my ruling is that they are not. But if anybody who thinks I'm wrong, you can proceed as if they are part of what you say are the present proceedings. I don't want when it goes to the SCA, where there are several guys I've trained, they'll say, I will charge you.
That's the court business.
Okay, so you can decide otherwise, but I'm making a ruling that they are not part and parcel. They are part and parcel of Maumela's evidence, proceedings. And those were set aside. Set aside. That's why when I came here, if you can recall, I said we are starting de novo and you've got a right to apply for bail. You remember? I said that.
Yes,
Thank you. Yeah.
indeed, but
Okay, no, let's
yes, yeah, just the final point that I want to make.
Yeah,
Because
what-
remember, the accused appears in the lower court, in the district court, before this magistrate, and at that stage, my lord, there were no problem. The magistrate there were no problems regarding those proceedings. The only proceedings in respect of which there was a problem, my lord, were the proceedings in the High Court, in respect of which, my lord, in our submission, the proceedings in the lower court did not form part.
Okay, fine. Yes, Mr.
With the guardians of the court, I don't intend to be long. But it is true that the proceedings that were before, I'm sorry to state here. It's true that the proceedings before the Honorable Judge Maumela were nullified. However, in this very same trial that we're busy with here,
Yeah.
we continue to refer to charge sheets that came from the regional court. For instance, I refer the court to Exhibit E.
No, I agree with everything you're saying.
Yes.
Except that in law,
Yes.
all those proceedings were nullified. I even tried to say, look at section 337. What? You just read 337.
337, my lord, if I were
Bail
to help.
application, that evidence in the lower court.
No, 337, my lord, has got to do with the estimation of an age of a person.
No, sorry, you're not 3.
Yes.
What's this 3? Just check that. Bail application, section 60. And
It should be
then-
around 60s, so.
No, but it's the transposition of proceedings in the regional court, making the bail application proceedings applicable in the High Court. You have it, sir? Got it.
Quick look, yes, I'm aware of that provision that says
Read it.
the bail proceedings form part of the subsequent proceedings.
Yes.
I'm just looking for the relevant section. That is why the accused must be warned of that fact that the bail proceedings will form part of the subsequent.
Yes, you are right. You
proceedings.
see, now you're getting it. That's why, for instance, as you say, the magistrate in the regional court, when an accused brings a bail application, is obliged to warn that accused to say, be cognizant of the fact that when you're giving evidence regarding a bail application in this court, that evidence can be referred to and it is admissible in the High Court. Now, here comes the JP here, Judge Lidwaba. He sets aside the proceedings to which this statement that the bail application proceedings are admissible in the High Court, but those proceedings are set aside.
I found the relevant section, my lord.
What does it say?
Section 60,
What's the section?
11.
Section?
section 60, 11B, subsection C.
Right, let's read
Says
it.
the record of the bail proceedings, excluding the information in paragraph A. Paragraph A refers to the
Yeah.
previous convictions
Yeah,
of the
fine.
accused. Shall form part of the record of the trial of the accused following upon such bail proceedings.
Thank you. Shall,
Yes.
don't even have a choice. Shall form part of the trial. And which trial are they referring to?
Yes. Well, any subsequent trial.
Yeah, which was, in this case, it was who? Maumela,
Yes.
right? But Maumela's trial has been set aside. And
Yes.
in other words, you can't come and apply for a bail application, you,
Yes, but
Mr. Gumizul, and then tell me that you addressed the court in the regional court.
yes.
Okay?
But the section clearly speaks of the bail proceedings. There was no bail application
That's it.
in the lower court in this matter.
That's it. So what's your problem?
So our submission is that this section refers to the bail. If there was a bail application, those bail proceedings will form part of the proceedings.
Okay, fine. No,
in
fine.
subsequent
It's a good
proceedings.
exercise. And of course, it refers to the very same 5 accused who appeared in the regional court. The same proceedings, which are the same accused. They were arraigned in the regional court. Is that not so? Right. Okay, you have heard me. Let's move, please. Let's move.
Yes, ma'am.
You say I'm wrong. Yeah.
I think my colleague is now being unfair
Of
when he says the section only refers to bail proceedings because it is him who introduced these exhibits, the charge sheets,
It doesn't say so.
the charge sheets that are from the regional court. Then he must make an application to withdraw them
You're right.
if they are not applicable in this trial. Yes,
The charge sheet was served in the regional court.
yes.
Now, when I listen to you guys, the charge sheet was served before Maumela. No. They were indicted in the regional court. Is that
Then the
not so?
state must withdraw this charge sheet.
No, it's okay, fine.
Thank you.
Well, just to correct my learned friend,
Okay, let's
section
proceed.
235 was
Let's
missed.
proceed. You are saying what, and I'm saying the ruling is no. But because I can't stop you talking, you can keep arguing that way.
As a court case, but we use 235.
Okay, fine, no problem.
le nkulumo ela ivele njengoba umnumzana uMvumezulu kathi kungahle kudlalwe le ndaba uma uNtanzi ephakamisa isandla ethi akafuni ummeli umjiyapho. Manje inkantolo ithi umnumzana uMvumezulu ucabanga ukuthi umthetho uyavuma na ukuthi lezi zinto ezisuliwe lezi bekuthi bezikade zixoxwa kuyicala uma inkosi yenkantolo kwakade kuJudge Mawume ucabanga ukuthi zingahle zisetshenzisiwe na manje njengoba leliyaqala liye la suswa kwathiwa kuqalwe kabusha ingakho no Judge Mukhahleng mayengena uye wanicebisa enjela ukuthi nani namalungelo wokuthi ningafaka isicelo sokuthi nikhishwe ngebhayili ngoba icala liqala kabusha manje balibele badinga indaba umthetho lana oyikuthi uyakhuluma ngebhayili futhi bakhuluma nangama-charge sheet ebekade ekhishwe laphayana enkantolo engaphansi i-regional court manje ithi inkosi yenkantolo asiqhubeke ngoba ngeke siliqede lolu daba singahle silale la sivuke nakusasa siqhubeke.
Hayi mina ngiliqedile usho kanjani? Yeah, okay, it's an interesting thing, because it's a question of interpretation, but it's not even that. Remember, Mr. Ngomezulu, I said, we'll now start arguing about which university did you go to.
Yes, ma'am. I remember.
You can't nullify something which started. When was the first appearance? Of the
27
On the
October.
27 October.
Yes, 2020.
When the DJP, the DOA was nullifying the proceedings before Maumen. He was wiping off the slate from the time these guys appeared in court. That is the nullity. Now, according to you guys, the nullity is just the High Court proceedings. And then the regional court proceedings are still current. Oh, madam. Okay, fine.
Just to mention, the proceedings were nullified not before the DJP but Judge Mo.
Yeah, sorry, yes. Okay, fine. Yes, Mr. Ngomezulu, Zwile again.
Zwile, ma'am. My lord, I was going to request an adjournment.
What's the time now?
It's 3:20, ma'am.
3:20.
Yes.
I'll still continue with this witness, Brigadier Sasa.
It's only few things.
So why don't we finish? If it's a few things.
It's an AVL, my lord, Muchiako. AVL Muchiako. Yes?
Okay, fine. Maybe you'll have to come back tomorrow. I'll tell you why. You are saying the section 105A, plea bargaining was completed. You heard yourself.
Yes,
It's an agreement, is that not so?
Correct, my lord.
Was it signed by both parties?
Insofar as I know, my lord, but that was between
Really?
us.
Was it signed by both parties? Even if, because of whatever you say, there are threats made to accused number 2,
Yes.
but it was signed.
My lord, they was signed.
It
Because
was signed. Okay, that's all I wanted to know.
Yes, my lord.
Yeah. And I'm sure the copy of that thing is somewhere.
There is a copy, like I've said, where I know the proposal.
Okay,
of
fine.
these things that I'm talking about, and there's a signature.
All right.
So it was a formal engagement.
Okay, fine. Tomorrow then at 10.
Yeah,